Okay, this is the first witness of the defense. As you can see, it's a recorded testimony. It happened at an earlier time. It's Dr. Travis Snyder. He's a neuroradiologist. He looks at MRIs, CTs of neck, sinuses, spine. Now, here's the thing. I want to go to Jonna Spilbor, our Law and Crime legal analyst. Jonna, great to have you here. You had mentioned to me the similarities between this case and another case of a parent accused of killing their children, Andrea Yates out of Texas. Can you elaborate on that?
Yeah, so way back when, I think the year was 2001, there was a case of Andrea Yates who coincidentally killed all 5 of her children as well one morning while her husband was at work by drowning them in the bathtub. Now, one of the crucial distinctions I see between that case, even though they're very similar, right? 5 kids, a parent. One of the crucial differences is she also claimed insanity, and it was successful. And I think part of the reason for that is she had a long documented history of postpartum depression and schizophrenia. I don't know if we're going to have, well, we're certainly not going to have postpartum depression in this case, but what is this defendant's history like? Because that makes a huge difference when you're trying to present an insanity defense.
Well, look, the law in Texas and South Carolina is different on insanity, but the similarities are you need to have some sort of mental disease or defect, and having a neuroradiologist on the stand who probably did some scans of the defendant, we might get a sense of that. Bob, real quick before we jump back live, the similarities between these cases and what might work for the defendant is if you have a parent like you had in Andrea Yates who deliberately killed all of the children one at a time, that's the same thing we see here. It's not as if all the children were in a car and you crashed the car and they all died. What I'm saying is these were all separate incidents. So when you talk about insanity, a lot of people question about whether it works because you have a conscious act after a conscious act after a conscious act. It's hard to say you had a psychotic episode that whole time as opposed to one instant. You see where I'm going with this?
Well, and as we heard with the Yates case, you had a long-standing psychiatric history. We don't know yet what the defense is going to present here, but to establish that with respect to this defendant. Also, the mother in that case, for some reason, may have been more sympathetic. And of course, we have 2 different juries.
Yeah, that is a good point. Now, Jonna, I want to go back to you. He's still qualifying himself. Nothing that we're learning quite yet. We'll assume that he's very qualified. Jonna, this is the question that I have for you. South Carolina law on insanity and the options for the jury, they're different than anywhere else across the country. Is that right?
It does seem, it seems actually quite different to me. And it almost, in my opinion, it might actually help this defendant because one of the things that they need to demonstrate is a failure of an ability to conform to the law. And that, I mean, Jesse, think about that for a minute. Every single defendant could say, well, at that moment, I was not able to conform to the law, officer. That's why I jaywalked. Like, to me, that's a very broad standard, and that might be helpful to the defendant.
Yeah, because there's this thing called guilty but mentally ill, and it's very different than what we've seen otherwhere, Bob. You know, usually what happens is somebody's found in, the jury has one option, either they're, well, 3. They could be found not guilty, they could be found not guilty by reason of insanity, or they be found guilty. And if they're found not guilty by reason of insanity, they go to a mental institution. Here it's a little bit different. It's almost like they cut the insanity defense in 2 and said, well, if you have a defendant who knew what he was doing was illegal or wrong, the next question is, okay, could he not conform his behavior to the law? And if you have that, then they could be found guilty but mentally ill. So that's different. Why do you think South Carolina does this?
Who knows?
Yeah.
It's their own take on how they want to develop that body of law. And I don't know enough about what the history was behind as to why they would do it that way.
Yeah, it's interesting. There's criticism of it. I mean, there's criticism that they don't really quite receive the same treatment as they would from a mental institution. So that's a criticism of it, but it's still South Carolina law. And I do want to reiterate this once more before we jump back live, that if the defense were able to successfully put forward an insanity defense, it would be the first time in South Carolina history that this would happen in a death penalty eligible case. Let's go back live. Okay, so Jonna, neuroradiologists, I'm sure you've seen them testify before. What would be the best thing for the defense here? They obviously have called him for a reason. What are we looking out for?
Oh boy. Well, one thing that we mentioned earlier is I think it helps the defendant if they can show that they suffered from a history of some sort of mental illness. And the reason is this, Jesse. Juries take this very seriously, and they're not apt to buy, you know, to coin the phrase temporary insanity as much as they do a history of some sort of mental illness that led to this final break that caused this horrible and disgusting tragedy. Everybody goes temporarily insane. I'm using air quotes here from time to time, and we don't kill our 5 children or anybody for that matter. So I want to see what kind of workup this expert did, what kind of history this defendant had, and exactly what caused this mental break. Because look, these facts are strange. Like you pointed out, there was ample time, Jesse, for reflection here, one after the other. There was time for reflection before he drove around with the corpses of his dead children in his car. So this expert's going to have, a real run for his money, in my opinion.
We talk about trying to get inside of a defendant's head. This is the literal example, and maybe not exactly what we were planning or thinking about. But Bob, Jonna makes a good point here in terms of what we can expect. I guess the question is, but really under the law, you can have a psychotic episode that's just for the killing. Sometimes we see cases before where you have a defendant who's had a history of mental illness, and that killing is just one part of it. But all they really have to show is that instance of killing, he had a psychotic episode. Am I understanding that correctly?
Well, yes, and Jonna makes a great point. And here I think what they're trying to show is that there's some medical scientific reason for this behavior. It's behavior versus disease. They want to kind of show that this person had a disease, I'm guessing is what we're looking for here.
Sure.
That there's a scientific explanation for why this person was here. It just wasn't somebody with odd behavior.
Well, at the very least, we know he's very qualified. I'm sure that's what we're learning right now. It gives us a good opportunity to take a break. When we come back, we're going to be live, and we'll get into the substance of what he's going to be testifying to. First witness for the defense. We'll be back.